Good afternoon, everyone. Welcome to our monthly Office for Financial Market Innovation and Digitalization, Blockchain and Innovation Circle. Thank you all for the interest. This time we have, in our view, in my personal view, an outstanding and exciting topic, namely the project European Blockchain Sandbox, led by the European Commission, with Bird & Bird as the responsible international law firm, with three highly competent and qualified experts. With innovation taking place at, let's say, breathtaking speed, interest in regulatory sandboxes is very strong and increasing. Regulatory sandboxes are no longer a new or exotic topic, as you might know. It can be defined as a safe space in which business can test innovative products, services, business models, and delivery mechanisms without immediately incurring all the normal regulatory consequences of engaging in the activity in question. The European Blockchain Regulatory Sandbox established a pan-European framework for regulatory dialogues to increase legal certainty, which is crucial for innovative blockchain solutions, as the blockchain itself is on its way to, in our view, change the economy in some time. Some information for the proceeding, as you might already all know, please drop your questions, remarks in the Q&A section in this webinar, which is highly welcomed, of course. If you have other inputs part, please let us know, and also afterwards on emails. So welcome to our experts, and thank you for your participation and willingness with your insights and lessons learned in this dynamic field. With that, we are pleased to give the floor first to experts, and first, of course, to Marjolein Geus as project leader, and as she is responsible for the main project. Thank you.
Yeah, thank you so much, Heinz, and also for having us. It's a great honor, and it's also great to join you at this session. And well, you are, of course, also a very, very valuable member of the sandbox operations. So also thank you for that. I'm here together with Wilfred Steenbruggen and Michael Juneman. Wilfred Steenbruggen is one of the key data protection experts in the European Blockchain Sandbox, and Michael Juneman, one of the key financial sector regulatory experts in the sandbox. And we are also joined by Livia Gazior, who is a member of the core team for European Blockchain Sandbox. Perhaps, Livia, we can go to the next slide. Just a few words, and then the next slide, about the European Blockchain Sandbox, what it is, objectives and key elements. As Heinz mentioned, the European Blockchain Sandbox is an initiative of the European Commission, which aims to establish a pan-European framework for regulatory dialogues, with the aim to increase legal certainty for innovative blockchain and DLT solutions, and at the same time to enhance understanding of relevant regulatory frameworks for the innovators, and also to help the regulators and authorities on a national level and on a European level to understand better innovative technologies, in particular DLT and blockchain technologies, and what that means for existing and upcoming legislation. So the first aim of the project is to set up confidential and informal regulatory dialogues about relevant laws and regulations between, on the one hand, the innovators, and the other hand, national and European regulators. The other aim of the project is to publish best practices reports to share the lessons learned, the best practices, also areas for clarification with the wider community, to the extent that those findings are not confidential and can be shared, which is always in agreement with the participants in the individual dialogues. It's a 3-year project, running from 2023 until the end of 2025. In every year, we work with 20 selected blockchain and DLT use cases. And we work then together for each cohort. We set up the dialogues with regulators and authorities across the whole EEA, all regulatory areas, and in fact also all different, or a range of different industry sectors. Perhaps we go to the next slide, and to give a bit of a picture how that played out in the first round of the European Blockchain Sandbox. And this is really a very, very encouraging slide, because it shows on the one hand that we had selected use case owners from all over the EEA, so all individual EEA regions were represented with selected use cases. And on the other hand, also equally encouraging, the dialogues are joined by regulators and authorities from all EEA regions again. So also a complete spread all over Europe. And the combination, also because the dialogues are cross-border, are really a pan-European project. And that was, of course, always the intention also from the European Commission, to make this really a pan-European project. Perhaps we go to the next slide. A few facts. So on average, in the first cohort, we had more than 4 regulators and authorities participating in each individual dialogue. Financial sector authorities, very well represented, but on the other hand, also not dominating. We had in the first cohort 6 financial sector use cases, and then also 14 non-financial sector use cases. In the second cohort, we have 9 financial sector use cases. So again, a very important project for the financial sector as well. But at the same time, also blockchain and DLT applications in other sectors are very relevant. In the dialogues, in the first round, we had a range from 1 to 8 regulators and authorities per dialogue. And that depended a bit on the use case, what made most sense. Also a good combination in quite a few dialogues between national and EU regulators and authorities, with 9 dialogues with a combination of both. Also great to see that several regulators and authorities participated in more than one dialogue. And also very important for our project is that the regulatory dialogues for 5 use cases focused on a combination of regulatory areas. And that is a very important element, because the innovators need to find their way across different applicable areas of regulation, and often there's a certain interplay between between 2 or even 3 different areas of regulation. Perhaps we go to the next slide. These are the chapters about regulatory areas that are covered in the first best practices report following the first round of dialogues. So we have 13 chapters, 13 different regulatory areas that were important for the first round of dialogues. During this session, we will focus on the findings for the GDPR and the financial sector regulation, but this gives an idea that there were quite a few other areas also relevant, and they are also discussed in the first best practices report, and the QR code leads you immediately to the best practices report. Perhaps the next slide. So regulation is often and is of course very important in the context of compliance. So ensure regulatory compliance of innovative use cases is one of the core topics for the regulatory dialogues, but it's important and also interesting to see that that is not the only angle of the European Blockchain Sandbox, because another important an aspect is that blockchain and DLT solutions are also suitable to support efficient and effective compliance and oversight. And that was also a very important element in quite a few use cases. For instance, in the supply chain area, that is really an important element that came out and that we are also discussing in the first best practices report. A third element, also important and a focus of the first round of dialogues, was that regulation is also there to help. If you look at, for instance, the eIDAS 2 regulation, or you look at MyCar, those are EU regulatory instruments that are actually helpful to and support innovation. So that is an important third angle actually in the dialogues, and we see that again in the second round, by the way. Perhaps we go to the next slide. So what is the status right now? The first cohort, the 2023 cohort, is complete. We had 20 selected use cases, 20 great dialogues, more than 50 national and European regulators participating, and the first best practices report was published in June of this year and is available on the website. The second cohort, there the dialogue is currently ongoing. So we have again 20 very interesting selected use cases in the second cohort. It's actually very interesting to see that these use cases are not always only focused on DLT, but also on the combination between DLT and AI, DLT and IoT, or cloud computing. So we really look at use cases that apply more than one innovative technologies. And of course, that also has an impact on the regulations that are relevant for those use cases. We have currently more than 70 national and EU regulators, and that is of course a significant increase also compared to the first round, and again encouraging to see that, because it means that not only from the perspective of the innovators, but also from the perspective of the regulators and authorities, this is really a European-wide project that is valued and interesting to be part of. We have additional regulatory areas compared to the first cohort. To mention a few already, we have the data regulatory area, so Data Act, Data Governance Act, Digital Services Act are really important in this cohort, and we also have use cases where the AI Act is relevant. Then the third cohort, we are currently preparing the start of the application process for the third cohort. It will start on the 27th of November, and the information can be found here using the QR code, which will lead you directly to the website. It's possible to subscribe to our newsletter to get the updates on the planning. And it's always possible to send us an email on the email address that is here mentioned on the slide, and we will be in touch and respond to your questions. The dialogues are expected to start in the second quarter of next year. With that, I would like to hand over to Wilfred to have a further look into the GDPR. Wilfred.
Yeah, thanks, Marjolein. I hope you can hear me all right. I wanted to share some insights from the sandbox in the field of data protection with you. Data protection compliance is seen as one of the key issues for blockchain use cases, and that's something that certainly our experiences in the sandbox have confirmed. When we talk about data protection compliance, we talk about GDPR compliance in the EU. The GDPR is an EU regulation, General Data Protection Regulation, that has since 2018 really reshaped the EU framework on the protection of personal data. As a regulation is directly applicable in member states, member states can still add some national rules to the GDPR, but only as far as the GDPR allows that. The GDPR regulates the processing of personal data. Now, we'll speak a little bit later about what that means for blockchain use cases, and has a couple of objectives. GDPR aims to strengthen data protection rights in a digital age, expands the territorial scope of the legislation, so it's not only relevant in the EU, but also for the processing of personal data outside of the EU in some cases. It extends obligation to data processors and data controllers, data control for citizens, and so on and so further. What's also well known, I think, about the GDPR is that DPAs, data protection authorities, have wide powers to investigate and to enforce these rules, and that can lead to high fines, sometimes very high fines, up to a maximum of 20 million euros or 4% of the worldwide turnover of an undertaking in some instances. It's not said that that will be the fine that is imposed, of course. It all depends on the circumstances. Next slide, please, Lydia. GDPR and blockchain have a difficult relationship with each other, and that's mainly because of two reasons. First of all, the GDPR assumes that there is a controller, or maybe two controllers or several controllers, that can take decisions on the processing of personal data, and that can also be held responsible. It's easy to see that that can be problematic in a blockchain setting where, in principle, the setup is decentralized and there is no central actor, in a lot of cases at least, that takes decisions about how data is being processed on the blockchain, on the public ledger. Second reason is that the GDPR also assumes that personal data will only be processed as long as is necessary for a certain purpose. As long as is necessary means, of course, that at some point in time it is not necessary anymore, and then the data should be deleted in principle. It's also easy to see that that is problematic in blockchain use cases, because the public ledger is in principle considered to be immutable. So the data that's on there is supposed to be on there permanently, as long as the blockchain exists. These characteristics lead to certain tensions with GDPR compliance, and these tensions mainly rise to the forefront in the topics that are being identified on this slide. So is there personal data processed on the ledger or not? Is there a data controller, or are there different parties that could qualify as data controllers that can be held responsible and accountable? What to do with the data protection principles, like storage limitation, purpose limitation, and so on, and what to do with data subject rights, for example, the right to erasure and rectification. These topics have been discussed in the blockchain sandbox. Please, Olivia, to the next slide. And the key question, I would say, the question that triggers all other questions, or that goes before every other question, is there personal data being processed on the ledger? And this is a key question, because if there's no personal data processed on the ledger, then the GDPR would not apply to the processing of the data, and that means that life is far simpler. What we have discussed in the blockchain sandbox is, and that was already well known, is that the concept of personal data is quite broad under GDPR. Personal data is being defined in the GDPR as data any information really that relates to an identifiable natural person, and that means that often personal data will be processed in a DLT context, and that can mean the data that is actually processed on the ledger as part of a certain transaction data, or it can be the keys, the public keys that also are being recorded on the ledger in the context of the DLT. It all depends, of course, on the question whether or not the data relates to an identifiable natural person. What we discussed as one of the findings of the DLT of the blockchain sandbox is that it's often the case, there's personal data, for example, when there's data being processed that relates to single person legal entities, like the one-man companies, for example. Data related to products can also be personal data. In principle, it would not be the case because it relates to a product, but it still qualifies as personal data when that data relates to an identifiable natural person. For example, when a user of the project of the product can be identified by the use case owner or a third party, or when there is data relating to repairers that are identifiable natural persons recorded on the ledger as part of the product information. Public keys can also be personal data when they are owned by companies. And that can particularly be the case when the data is when these keys are also always used by the same person. In that case, it could be that the usage can be followed, monitored, tracked across different transactions, and that also can lead to the potential identification of the natural person that is actually handling these keys. What we also discussed with the regulators is that simply encrypting or hashing data on the ledger, personal data before it's put on the ledger, is unlikely to make the data anonymous. This encryption or hashing leads to pseudonymized data, in the words of the GDPR, and pseudonymized data is data that is in principle better protected, so that not everybody can easily trace that back to an identifiable natural person. But still, because somewhere there is information available that could be used to come to identification, this data is considered to be personal data, and that means that all the requirements of the GDPR apply. If at a certain point in time something like encrypting or hashing is being implemented, it's really always very important to do a case-by-case assessment if the identification measures are sufficient to qualify the data as really anonymous data. What is good to know, and it's also something that we discussed with the regulators, is that the concept of personal data is still a little bit uncertain. There are, let's say, blurry ends that are being discussed with the regulators, also in case law. What applies today could maybe be different tomorrow. The regulators are working on guidance with regard to pseudonymization and anonymization. And they are also working on guidance with regard to blockchain in particular. And there's some case law at the level of the Court of Justice that might change the interpretation of the concept of personal data going forward. But at this point in time, it's very clear that regulators are quite strict when it comes to the qualification of data as personal data. So it should probably be assumed that whenever the data still is linkable to a identifiable person somewhere by someone, then it should be treated as personal data, and that would then in practice mean that you would have to look at the requirements of the GDPR. Next slide, please, Livia. And that means a couple of things, of course. First of all, means that you would have to determine the data protection roles. Is there a party that could qualify as a controller, that could be responsible and be held accountable for the processing of personal data? Under GDPR, the concept of controller is defined as any party that determines purpose and means of the processing. It is the party that takes the important decisions. So decides whether data should be processed, for which purpose, and also how, which data should be processed, etc., etc. That always has to be assessed in the context of the specific use case. Who could be the controller? Mostly the parties that use that operate a certain business using blockchain could be considered the controller for GDPR purposes, but could also be that they are a processor and their customer is the controller. One of the findings of the blockchain sandbox is that in a permissioned blockchain, node operators or miners would likely qualify as data processors. And that means under GDPR that there should be data processing agreements put in place, meeting certain requirements. In a permissionless blockchain, it's more difficult to define the data protection role of the node operators. So that's something that we're discussing in the next dialogue, the second and the current second and third dialogue. Also important under GDPR is that there is a legal basis for the processing of personal data. The GDPR recognizes 6 different legal bases that controllers could rely on to process personal data for their purposes. Consent is one, performance of a contract is another, legitimate interest is also an option, legal obligation. Some of these legal bases are difficult to implement in a blockchain setting. Consent, for example, comes with a lot of strict requirements, which makes it often difficult to implement it in a way that it's really a valid consent. Legal obligation is also a difficult one, because if you have an international blockchain use case, you would have to rely on a legal obligation in all of the member states, except for the case that there is an EU law that could provide a legal obligation. So can be difficult sometimes. What we discussed in the sandbox is that maybe performance of a contract with a data subject could be sometimes an efficient and harmonized legal basis for many use cases, but it has to be determined on a case-by-case basis. Transparency is often also key for the compliance with GDPR, as a lot of data processing principles somehow rely on the information that is being provided to the individual about, for example, the purpose of the data processing, whether or not data can be stored on the blockchain permanently, is something that could be addressed by just providing adequate information. We also talked about the data subject rights, mostly about the problematic data subject rights. These are the right to erasure and to a lesser extent the right to rectification. As I said before, the immutable character of the blockchain makes it difficult to delete personal data that is processed on the ledger, on the public ledger. And one of the things that came out of the sandbox is that it's recommended to store personal data as much as possible offline and only record, let's say, hashes or commitments on the ledger that can be not deleted, of course, on the ledger, but the link between the offline storage and the data on the ledger can be broken. If that's the case, and the data on the ledger is, let's say, meaningless, and also the data off-chain can be deleted, then regulators are inclined to think that is a way to come to a proper erasure. Also, this has to be determined, of course, in the context of a specific use case, how that could work. And we also discussed, as a last point, in the blockchain sandbox, that it's important to apply appropriate encryption and or other privacy-enhancing technologies to ensure that only very limited personal data is stored on the blockchain, if at all. And other measures are also taken to help to minimize the risk in the case of a data breach and to secure the data during the transfer or storage. Livia, next slide, please. So far, the findings for the first cohort. In the second cohort, we're looking further into anonymization methods and also in the role of the node operators in a permissionless blockchain. We are, of course, very curious to see what that will bring in terms of new findings that we could share with you in a later stage. This is it for me, Michael.
Yes, happy to guide you a little bit through some of the financial regulatory topics that have come up in the sandbox, and we have chosen some examples that sort of may stand for typical discussion points that we have in regulatory dialogues, financial regulatory dialogues. One of the sort of first and very basic topics that we encounter all the time in the discussions is a discussion around non-fungible tokens. As you all well know, that fungibility is a relevant term both in MiCA and MiFID to determine whether a crypto asset within the sense of MiCA is given, or whether a financial instrument under MiFID is given. Oftentimes use case owners say, okay, we have built our token on the basis of the ERC 721 protocol, and these are non-fungible tokens, and since they're non-fungible, obviously we do not fall under any of those regulations. And that causes a lot of confusion because technology sort of characteristics do not always meet legal characteristics. As we all know, also in the past, when we have some very traditional certificates of shares, for example, they all were carrying serial numbers, and still no one would argue that those certificates were not fungible in the sense that they would be 100% interchangeable just because they had serial numbers. No, that's not the case from a legal perspective. You need to go through a separate qualification, and therefore fungibility needs to be determined on the basis of the legal term of fungibility, and the technical characteristics of a non-fungible token may still not be sufficient to exclude legal fungibility for the reason that I've just described. So if we have a token and each token distinguishes from another token, for example, just by a serial number or just by one characteristic, but otherwise it gives the token holder the same rights and sets. We say from a legal perspective, they are interchangeable. Nobody would mind whether they have token number 1 or number 2. Another element, obviously, is transferability, and there sort of oftentimes we come to the question to what extent may tokens be transferable, and there are use cases where, for example, the issuer mints the tokens and burns them instantly, and therefore that may be an indication that a token is not transferable. And there's another topic that came up. We had quite a discussion around tokenized deposits, and whether they could be electronic money tokens. And it could generally be argued that this is not the case, because deposits are regulated actually by other regulations. So they are mentioned in MiFID as structured deposits. They are mentioned in the deposit protection regulation, and therefore maybe this is a different animal from electronic money. But further guidance from the regulators would be welcomed. Also, in my view, my personal view is there cannot be electronic money, because electronic money needs to be accepted by multiple persons, and deposits, their characteristics is in my view always that they're with the same bank. So it may be possible to transfer one deposit into another deposit of a different deposit holder within the same bank, subject to AML, but it's not really the same transferability as you would have with electronic money. So that sort of brings us to a little bit of the first findings that we have, and that there is a delineation between MiCA and MiFID. As you may well know, the MiCA regulation says it's applicable to anything that is not regulated under MiFID. And in this little table below, you then see sort of the different concepts of those regulations. But the interesting point that we had discussions around during the dialogues was actually the fact that with this form of sort of reference, MiFID is a directive, and the national law implementations of what is a financial instrument under MiFID is not always 100% identical. So the question really arises, what is happening if one member state says a specific token is a financial instrument and another member state says, no, it's a token under MiCA. So there was clear result that in the sandbox that there needs to be some sort of alignment needs to be done to ensure that sort of if we want to have a pan-European market, that regulators need to sort of find a form of approach to that, which could be, for example, a home state regulator decision is then binding on all European regulators or something like that in that respect. But this topic comes up in multiple use cases where we have situations that may be seen differently country by country, and then the question really arises, what is applicable to the specific token if it sort of crosses the border. And the question is obviously also very important for those that are offering services in relation to a specific token, maybe exchange services, maybe other financial services, because for them it's also important to understand which license they need to hold, whether a MiCA license, for example, as a crypto asset service provider is sufficient for them, or whether in some countries they may face a situation where the regulator tells them, no, you actually need a full-blown MiFID license to offer those services. So it's a very crucial point that came up in multiple use cases.
Perhaps we have 5 more minutes, Michael, I think, and then have some time for questions.
Yeah. Another topic that oftentimes came up was in the context of payments or transfers of tokens. And we have just sort of, for ease of thinking, we have here 2 pictures of scenarios that we typically encounter. One is obviously that the DLT application provider sits in between the token holder and the token owner and the asset holder. And if these contractual arrangements are structured like this is very, very likely that the DLT application provider falls under some form of regulation. Maybe it is an issuer, maybe if it's a transfer, it's a service provider in a sense of either a payment service or crypto asset transfer service. Scenario 2 is a little bit more tricky. Then the question arises whether the DLT application provider may, for example, only offer software services, and actually the asset holder and the token holder are the 2 that are directly interacting. For example, if this were an IPO situation, the asset holder would be offering the tokens. And if the DLT application provider is simply selling a software license to the asset holder, it probably fall outside of the typical scope of MiFID or MiCA services. If the DLT application provider would, for example, broker or the actual underwriting or would place those tokens with the token holders, it could obviously be a MiFID service or even a crypto assets service in relation to the placement or otherwise within the IPO scenario. Next slide, please. And there we have sort of some thoughts put into this in terms of what is actually the delineation between crypto asset services and payment services. Again, it's very important to understand there what types of token we are facing, but oftentimes it is obviously that then different aspects need to be assessed in relation to the exchange of tokens or the transfer of tokens. For example, if nobody actually is if the relevant sort of use case we are looking at is not receiving any funds, and if so the token is not sort of flowing through any public address or wallet of that service provider, then obviously that is an indication that this provider is neither offering a crypto transfer service nor a payment service. But on the other hand, even in such situations, smart contracts need to be considered because the regulators have most of the time taken the view, even if you're only sort of providing a smart contract, and the transfer is happening directly between public address or wallet of the transferor and public address or wallet of the transferee. But you are someone is in control of a smart contract that sort of operates such transfer automatically. Still, such a control could be seen as qualifying the controller of the smart contract as a service provider. And then obviously there are different scenarios if sort of funds as required in the definition of money remittance are paid on both sides of the use case owner, then it may very well be a payment service. But if such transfer is in tokens or crypto assets on one side, then it's rather likely not a payment service, but maybe it's then some form of exchange, tokens against funds. So it's more likely to be an NFT or something, some crypto assets service of that kind and nature. Providing transfer services for cryptos on behalf of clients can therefore always be a crypto asset service, regardless of whether it can be qualified as an exchange, and therefore should be licensed under MiCA. That's just in a minute can be seen on the next slide, and the delineation between payment services and crypto asset service always depends on the qualification of stable coins as electronic money or not. So if they're qualified as electronic money, then obviously they are qualified as funds, and therefore then the payment services provided. While on the other hand, if those tokens that are transferred are crypto assets within the meaning of MiCA, then it's a crypto transfer service. And this sort of table only briefly shows you what are the relevant aspects. So I can leave it like this, and you can have a look after the presentation, just briefly what sort of the different applicable regulations could be in various scenarios.
Yep.
So, thank you very much for your insights and a very interesting presentation regarding this innovative topic. Are there any questions for the participants? We are open for questions now, or of course afterwards, just a normal mail or phone or whatever. Yeah. If not, maybe from my side, if you have your knowledge and insight from 40 projects, sandboxes and blockchain sandboxes in Europe, what is in your view the main advantage to settle a blockchain and not the traditional way of going in the economy? What's the main advantage, or what are the main advantages? Of course, there are several in our view.
That is not perhaps not primarily a legal and regulatory question, but that is a question about the technology, I think, Heinz?
Yeah.
And well, you can of course doubt whether we are the experts in the technology, but I must say, being a regulatory specialist myself, I think I was really impressed by many of the use cases that were presented, by how they make use of blockchain and DLT to ensure transparency, security, verifiability, and that is, from a compliance perspective, that can be used in the advantage of both the innovators, so the market players, and the regulators and authorities. So I think if you look at it, and that came across many use cases in different industry sectors. If there was the application of blockchain DLT and there was a cooperation between regulators and authorities on the one hand and the innovators on the other hand, that could have really advantages for both the market players and also the regulators and authorities to make compliance more effective, more efficient. And of course that and everyone needs to be comfortable with that. But I think that was, for me personally, one of the real eye-openers, and also facilitated by the sandbox setting, because in the sandbox setting, regulators and innovators are looking at regulatory issues actually from the perspective of finding solutions there. And that is a very different approach from being at two sides of the table and actually not being in a real dialogue. But Michael, I don't know whether you have you definitely have additional.
Yeah, I mean, it's the sort of the biggest advantages that of the European sandbox over sort of national sandboxes, which have both in common probably that sort of new use cases come to the regulators much earlier than they otherwise would, and therefore the regulators have more time to consider those and apply prudent regulation. I think that's sort of a given in any form of sandbox. The biggest sort of add-on of the European sandbox was this aspect of one single European market. We saw these things with sometimes 11 and more regulators on one use case, and they sort of openly discussing these use cases from a very practical perspective, and us understanding sort of where the difficulties were in terms of rolling out a certain business model that may work in one country, may have even already been approved by a regulator in one country, and then potentially facing difficulties going cross-border based on European regulations, because it's there are still these sort of tiny little non-harmonized laws or different views of regulators that may make it difficult. And I think it's fair to say that if you look at those use cases and if you look at how they are funded by venture capital, none of these use cases that we have seen, and I think only a very small fraction of use cases actually are planning in their business plan to stay in one country. So that's always part of those use cases, at least those that are venture capital backed, that they want to make use of the single European market, just as in the US, and that's otherwise we are actually as an economy also not competitive compared to the US, and all those use cases would immediately start in the US because of the size of the market that they have, and venture capital would even more only back them in the US.
Thank you. That's one question which was upcoming, maybe to explain for when the application process is expected to be open again.
Sorry, Heinz, can you please repeat that?
Just one question which was upcoming. When the application process is expected to be open again?
Okay, that's the application process for the third cohort.
Yeah,
yes,
for the third one, yeah.
Yeah, that will be on the 27th of November, so the 27th of this month. And from that moment onwards, the application form will be accessible through the website or on the website, but we also share that in the newsletter and also on social media, and the application term will run until the end of January 2025.
Perfect. There's one other question regarding the GDPR. I think, but Wilfred is not here anymore. The question was, how do you see GDPR shaping the development of new blockchain-driven business models and vice versa?
Well, yeah, Wilfred is no longer in the meeting, but I can share my perspective there, and that is that, of course, GDPR is very relevant for almost all use cases, and compliance, therefore, well, that is a key element. But the fact that the GDPR is applicable, that is not the end of the world, as the regulators were saying during the dialogues. You can find solutions, but it is really compliance by design. You need to, in the setup of how the use case is operating, well, to take on board some of the key elements that are needed. So and what was stressed very clearly was, it's important to, if you have personal data on chain, to keep that as limited as possible in an encrypted manner. That is very, very important, to think already through how to address the user rights. So it can be done, but it's important to take it into account when setting up.
Thank you. As there are no questions left anymore, and we are just in time, I think, because we have Marjolein has the next blockchain sandbox upcoming in 2 minutes. So I believe we come to our end here. Thanks for your statements, the insights, the presentation as well to you. I appreciate it. It proves in an impressive way the blockchain topic is here to stay and will develop in a fast and maybe in a disruptive way in a lot of fields of the economy, not only in the financial market, but in the financial market field as well. So thank you everyone for listening and your valuable questions. We hope to see you very soon. The next week is already in mid-December. And of course, we keep you posted for your next upcoming blockchain and innovation sector. So thank you a lot. We wish you a nice and successful afternoon and rest of the week, of course, as well.
Yeah. Thank you so much.
Goodbye.
Bye.
Thank you.